Board. The board today is made up of myself, Mayor Mike Parkinson, City Clerk Jennifer DeYoung, and Senior Alderman Dan McDowell. This is the case of Michaeline Millis, the petitioner or objector, and the versus the respondent, Jennifer Flores, responding candidate. Our agenda today reflects how we're going to proceed today, and hearing no objections from the board members. We will be following the election code 10 ILCS 510-10. Hearing no objections from the board today, those rules will stand. The hearing will proceed as follows. The electoral board will allow any public comments at this time and will follow the rules of the City of Granite City for open meetings. Do we have any public comment? You have public comment? Yes, sir.
Yeah, I'm just.
Please come forward.
Oh, okay.
So you'll have 3 minutes to complete your statement to the hearing today. Could you identify yourself for the record, please?
Yes, sir. I'm Robert Weathers. I work on a school district, and I'm here as a neutral party for a conservative group here in Granite. And I just want to make sure that we're not doing as the federal voting went and trying to kick off Trump as far as ballots go. So we want to keep this fair in this city, and I'm just here to see what the proceedings are going to be.
All right, thank you, sir. Anybody else? All right, we'll move forward then. The electoral board will allow any public the procedure today will be for the objector to present their case first, and will be allowed 10 to 15 minutes if needed for their presentation. The respondent or candidate will then present their case and will also be allowed 10 to 15 minutes for their presentation. The objector will then be allowed a 5-minute period to close their arguments, followed by the respondent having the same 5-minute period to close their arguments. The objector will then have a 2-minute period for rebuttal. The electoral board will then deliberate in open session and decide to render a decision or take the matter under advisement and render a decision at a later date. If a decision is rendered today, the parties can waive their legal service and accept their written copy of the decision and date and time of the hearing for written notice by email. Objector, do you waive your legal right and accept your service by email?
Yes.
Thank you. Candidate, do you waive your legal service and accept notification by email?
Yes.
Thank you. Clerk, would you swear in any parties to testify? Will you guys be testifying under oath?
I will not, just arguing.
Thank you. Ms. Millis? And will you have anybody testifying under oath?
I won't, but I do need to make a statement. I would like for you all to know that I'm going to be presenting evidence against an illegal chain of custody of the signature papers that involves Jenna DeYoung as well as Michelle Hillman. Because Jenna's on board right now and Michelle is in here, I suggest that we remove them because if this does go to appeal, it will wind up going to civil court and then potentially criminal depending on how it's resolved.
I'm the city attorney, Brian Conson. Ms. Flores, you're aware the election code requires this board to include the city clerk.
Yes, I do.
You're aware of that?
Right, but
You're aware that by
at any
statute,
time. Okay, go ahead.
you're aware that by statute, she also is the local election authority.
Correct, unless she's involved in something that is nefarious. So yes.
Well, I don't think that word's in the statute.
Okay. So you're going to remain the house for your own counsel?
I would recommend to the board that they stand as they are supposed to stand by statute.
Okay.
Which is the senior alderman, Mr. McDowell, the city clerk, and the mayor.
Okay. So that's your
If
recommendation?
you want to make further argument, I'll let the chairman certainly entertain it. But
It's up to them if they want to take that responsibility that, that brought up.
We will take your comments under advisement. Will you be testifying under oath? Or just presenting your evidence today?
I'll be presenting evidence.
The board does have the right to ask questions of you.
Yes, correct, yes.
Then I will ask her and then place you under oath. Right?
Oh, okay, that's fine.
Are you testifying before the officer?
It'll be these two. Do either party have anybody else that needs to be?
No, just
Raise your hand.
Please stand up.
Yeah, raise your hand. Do you solemnly swear or affirm that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth?
Can I also ask, do we have an agenda prepared? Should we provide with an agenda?
The agenda was provided to you by
By mail?
yes.
That is not correct. I did not receive that by mail.
You can take that up with the legal matter.
Okay, that's fine.
The records indicate that there was a
Absolutely. It's also posted on the website.
Yes.
It needs to be hand delivered to everyone in attendance today.
Ma'am, that was answered, we're moving forward. You can
Okay.
take that up in your appeal if you wish.
Sure.
I will turn the floor over to Ms. Melissa, I'm sorry, would you state your name there?
Katie White.
And you are the attorney of record for Ms. Melissa.
Yes.
Thank you. You have 10 to 15 minutes.
Mayor, we, on behalf of the petitioner Jennifer McLean, today, we would argue that under the petition packet, that the respondent is invalid, first reference to the law itself, which is election code 10 ILCS under the Illinois Compiled Statutes 510-4. There are a couple issues that were found with the petition packet. The first being that under the law, that 10-4 states that the, 10 ILCS 57-10 and then 10-4 both state that the petition signature sheets must be neatly fastened together in book form at one edge in a secure and suitable manner. The petitioner, the respondent, Ms. Benda, I apologize, Ms. Flores, which is the wrong sheet, her petition packet was filed with no binding. And I would like to draw attention to the receipt form that we filed FOIA on today, Freedom of Information Act, on the election candidate documents. It is public record. This is something that is filled out when the candidate does submit her petition papers, and there is a spot on there that says manner in which petitions are bound. It's either be not bound, binder clip, staple, paper clip, or other. Is checked not bound. So under the law, it is not bound. The petition papers were not bound, which is a fatal flaw in this part. The law does state, as well as case law states, that the statute states that the word is that the petition shall be bound, which is presumed mandatory. Therefore, if the petition papers are not bound, then that is a fatal flaw and the respondent's name must be removed from the ballot. That was the first issue that we saw. The second issue that was found under Election Code 10 ILCS 5/7-10, that code states that the candidate's name should appear in exactly the same form on the petition sheets, statement of candidacy, and loyalty oath. That did not happen here either. The statement of candidacy showed the candidate's name as Jennifer, and then quotation marks, Jenna Flores. The loyalty oath, however, showed the candidate's name as Jennifer Flores. The petition pages 1 through 5 listed the candidate's name as Jennifer Flores. And for that reason, the nomination papers are invalid for that reason as well. And last, the third flaw that we found is that the following signatures should be stricken and disqualified because as you can see in the petition, there are several signatures where they are not registered voters. And under the law, obviously, signers of the petition must be registered voters in Ward 2, City of Granite City, Madison County, and the 8 signatures that are listed in the petition are not registered voters. So because of the 3 flaws, the petition signature sheets not being bound, the signatures not being in exactly the same form on the petition sheets, statement of candidacy and loyalty oath, as well as the voters not being registered voters in Ward 2, City of Granite City, Madison County, we believe that the respondent, Jennifer Flores' name should be stricken from the ballot.
Okay, anything else?
Not at this time.
Would you like to submit any of those items to us for the record?
I believe I have a receipt form. This would be wrong for me. I'll be in the clerk's office, but I will.
And I guess one question I would ask, do you have anything showing the validity of the signature?
Under the Madison County Clerk's Office, there should be certified copies that the voters or not registered voters with it.
And you've reviewed those, and they're not valid?
They are not valid.
And does that take her under the limited number of signatures she's required to have?
The number is 176.
That is not correct. The number is 23.
I believe 176 is for the...
It's for the mayor.
It's for the mayor.
Mayor, I don't have the answer to that question right now.
So is it correct that you're making accusations that have nothing to
Ma'am,
provide?
ma'am, please stop. You will have your time. So you don't have, do you know if the removal of those 8 ticks are below, didn't you know what the statutory number is?
I did not, I would have to remember the sheet, and I don't know that.
Dan, did you know how many you had?
It's my understanding that it does not take it under.
Okay, this
That's not
okay.
correct.
I have minimum 42, maximum 92.
That's for your area, for mine is,
That's for the third ward.
I'm second ward,
So
it's 20.
So your presentation today said that with the 8 involved signatures, she's still above the threshold.
Still above the threshold, correct.
I don't have any more questions. Do you have anything further for the case?
No, Mayor, thank you.
Ms. Flores, you have 10 to 15 minutes.
Awesome. Okay, so the first thing I present to you all is what was presented, served to me when I had here yesterday for my county court. It is a properly served document that one would receive when they're getting called, I'm not sure if it's supposed to be heard. And it includes evidence, which would be copies of the signature papers that all needs to be provided in order for proper service to be given, in order to be even here in court today. And so I've got certified mail that just came with nothing. Today we have an attorney that presented nothing. And again, I have nothing but a 2-page paper that is her objection. And then I have 2 pages that told me I had to appear today, not including her objection, which she needs about 3 copies of. And we have no evidence, no copies of any signature papers, nothing proving what she's saying. So that's where we're at with that. I believe that this should be dismissed based on improper service.
Do you have any rebuttal to the issues presented that your papers were not filed?
Yes, I do have rebuttal to that, but I believe that we should take this under advisement first from the board before we proceed. Because that's what,
We're going to proceed with the hearing.
okay,
We will listen to your objections
Sure.
as we caucus and
Okay.
decide whether we make a decision today or not,
okay,
as a 3 panel.
yep.
So we will take that as part of your case. But this is your 10 to 15 minutes to present any facts you have in rebuttal.
I got it. All right, so here we have the paper that was filled out, and as you can see, there is a check mark series here, and there's an initial that is provided. What we did when we submitted paperwork was we brought the signature pages up after they were notarized, but we did not have the economic statement yet. We knew that we had to go back up to Edwardsville and get that information. So we gave this to the city clerk so she could hold our papers for us. At that time, she checked not bound, because that's what she saw when she received it, but that was not our submission. We came back in 3 hours later, we had our economic statement, we had another person who signed off on this, and then this was not updated to reflect that it was properly bound with a metallic clip. So this is void. I have copies of that as well. So chain of custody was not followed properly by the city clerk's office in its entirety with this.
So it's your testimony today that when you returned, so you showed up one time, it turned in.
Every morning, yes, at 9 a.m.
And then, did you turn in your packet at that time?
We did not submit the packet. They started our paperwork because we knew we had to go up and get the economic statement. So they held it for us there, they checked off what we had, but at that time, the city clerk, who was not present when we returned 3 hours later, checked off it was not bound. So she went out of order and she checked something that was not properly submitted. was also not in the office when we returned, when we had the signature from Michelle Hillman, and we did not have any clarity on that at all at the time.
Okay, so when you returned, you were given this form, and it stated, it was checked off that it was not bound.
Correct, that was checked off that way, but it was not checked off by the person
Do
who
you
was.
remember how you bound it?
Yes, we had metallic clips,
The top clips with holes
Yes.
punched in it?
not holes punched in it, no.
Okay, so what kind of metallic clip?
It was a clip made out of metal.
Paper clip?
It was a clip.
Alligator clip?
It was a clip that we used to fasten the paper. I'm gonna
Your
ask
testimony
one
today
clips
is not
here.
remember what you bound it with, but that you bound it.
We did have clips, yes, available. Either way, even if it was a paper clip or metallic bound, it still qualifies.
Right, anything else?
Yes, I still have things to share. I want to also bring up that if someone who is an employee of the city is the person that is objecting to the candidate, and they're the payroll for the city, that can be seen as illegal. I am submitting the payroll from October city council meetings showing that Michelle Nealis is being paid and working for the city and has been on and off. So therefore, she is not appropriate to be an objector in any of these situations, and again, all of her objections should be rescinded.
Anything further?
Right now, no.
You have, 5 minutes. 4 seconds.
With regards to the binding, I believe the respondent obviously did not, her argument is fairly self-serving. Without any evidence, without anyone.
Please stop.
Thank you. Without anyone testifying on her behalf, whether calling anyone up to the stand or to testify that he or she did not take or did take the binding, then the point is moot. And what we have right now is that the document that was submitted to the board basically saying not found. And there is no other evidence or to the contrary, than what the respondent has argued, obviously, and she's going to argue that that's not correct, that other people were involved, then those people should have been called in her case in point, but they were not called, and therefore, we go by what we have, and that is that the statute requirements were not met, which is a fatal flaw, and that may be removed for valid cause.
Anything further?
No.
It's the burden of the petitioner that is objecting that she has to actually show proof that it wasn't found that day. She was not present, she wasn't there, she didn't call any witnesses either. And I can tell you for sure that, this is a situation where if you guys had cameras in the city clerk's office, we wouldn't have this question.
Anything further to us? Ma'am, we have 2 minutes for you. 14, yes. I'll start the clock.
There is a picture, Mayor, of the unbound petition. I don't have it printed out right now, but I can get that to the board.
Who took that picture?
Right. Okay, we will accept that from you if we do not rule today. If we decide to take this under advisement and rule at a later time, if you could provide that for us, we will take that under advisement. Okay. Anything further?
No, thank you.
The electoral boards now will deliberate in open session and take this decide whether we're going to rule today or not. When the hearing is completed, we'll advise all parties that the hearing on the ruling will be held on Monday, December 9th, 2024 at 10 a.m. And written notice of the decision will be provided at that time. If a party does not appear for receipt of the decision shall be deemed to have been served on the absent party on the date when a copy of the decision is personally delivered, or on the date when a copy of the decision is deposited in the U.S. mail, and a sealed envelope or package with postage prepaid addressed to the party affected by the decision, or to such party's attorney of record, if any, and the rest of the record of such person in the file of the electoral board. That is all also stated in the election code.
Mayor, I'm sorry to interrupt, but I do have a picture.
Oh,
I got stuff or something, so I can submit that as well.
Okay, is this a picture obtained from the clerk's office?
Yes.
Is it your understanding that this was the way that it was turned in at the time it was submitted to the clerk's office?
It is my understanding, Mayor, and I could have the city clerk testify if she's the one that accepted it.
She's not accepted.
Okay, I think this was accepted based on what we've been presented today by possibly by Ms. Holman.
No, sir.
No?
No, sir. The only thing I accepted was the state of the economic statement. That's the only thing that I was saying. Everything else was given to the clerk, and she took pictures of every single.
Let me stop you, Ms. Holman. Would you like to call a witness?
I would like to follow with it.
Okay, under this hearing, I would say that, I don't think you can call this Lindy Young in your rebuttal. We're in rebuttal, you've already moved past your time to present witnesses. Okay? Right. Yeah, based on the procedures that were presented today, we're in your last 2 minutes.
Hey, give it to Tom.
That
to the gentleman in the seat.
Disregard anything that was presented today.
Yes.
I would like to reflect that I have 3 items of exhibits placed on file by the candidate, and I have 2 exhibits placed on file by the petitioner. I will mark them 1 and 2 from the petitioner, and 3, 4, and 5 from the respondent. Okay. Do you guys, are you prepared to vote now? Or take them in the election? You're prepared to vote? Yeah? Sure. I do as a matter of procedure, need to place on record the certified service provided to Ms. Flores, along with the copy of the U.S. Postal Service mail. The service to Ms. Flores was signed by a county deputy, 12-2, which she accepted the service. Okay, hearing all the evidence and what was presented today, I do find that, and I will label these, I'm sorry, they will be 6 and 7. In the complaint of the paperwork not being bound, Dan, do you find that to be a violation? Christina?
Yes, I do.
I concur and find it as a violation. In the matter of the name not being the same in validating forms as for Jenna Flores and Jenna Flores, do you find that to be a violation?
I do.
Christina?
Yes, I do.
I as well. In the 8 valid signatures, that doesn't take it below the threshold, do you find that to be a violation?
I do not.
Christina?
I do not.
I concur, I do not as well. Is it the opinion of this board based on the 2 violations found that the candidate should be stricken from the ballot?
Yes.
Christina?
Yes.
I'm a yes also. That will conclude the hearing today. Notices will be sent out.